Hello everybody and welcome back to another episode of P.I.P, People in Property, with myself Adil Niazi from Key Property Consultants. Today I've got the lovely Nosheen from Manak Solicitors to discuss with us wills and probates. Hi Nosheen, how are you?
I'm very well, thank you, Adil. Thank you for inviting me today.
Thank you for coming down and taking the time out of your day. I know you're very busy all the time, which is fortunate for the company, but unfortunate as obviously people are passing away. That's why you gotta get busy.
Thanks.
So tell us a little bit about the company first before we sort of get into like nitty gritty about power of attorneys and wills and stuff, if that's okay.
Yeah, that's fine. So I work for a firm called Manak Solicitors. I've been with them for nearly 7 years. We have offices in Orpington and Sevenoaks and Gravesend. And so we are a high street firm. We offer most services. So conveyancing work, family work. We also do immigration, a little bit of criminal, not any personal injury. And I'm head of wills and probate. So my work primarily consists of helping people ensuring that their legal affairs are in order. So their wills are in order. If there's capacity issues, they've got powers of attorney. But as I say, it's a local firm. Most of our client base comes from recommendations and referrals, which we always think is the best way, as you know, to operate any business.
Of course. So now let's delve into a little bit about, you know, the importance of having a will in place. And obviously, like you said, if there's capacity issues, power of attorneys, which a lot of people don't know about. So let's enlighten the viewers and tell them a little bit about what's involved, what it takes and what people should think of doing, and maybe at what stage of their lives they should think of doing these things.
So I think as soon as you own any asset, you should think about putting a will in place. So if you own a property, then really you should be thinking that if, God forbid, anything happens to me, who will my property pass to? So the purpose of a will is really to set out, firstly, who should deal with your estate if you suddenly pass away. And secondly, who should your assets pass to? Because, you know, you may want it to pass to your children or to your spouse. So a will is used to set out where your estate should pass. Now, it doesn't really matter what your estate's value is. It doesn't matter if you've got an estate worth 100,000 or £1 million. It's about who deals with my estate and who should my estate pass to. Wills can be used also to ensure tax efficiency. As you know, the government will want their inheritance tax paid, unfortunately, when somebody dies. And to be tax efficient, it's always a good idea to pass your estate to your spouse in the first instance, so you can qualify for the spousal exemption. And then if you have a property, to pass it on to your children, so you can then qualify for the residence allowance, which for a married couple, if you have a property that you're passing to your children, that gives you £1 million allowance. If you don't have wills in place, then your estate passes in accordance with the intestacy rules, which sets out who your estate should pass to. So a lot of people assume that, if they die, everything will automatically go to my wife or my husband. Mm-hmm. And whereas joint assets do, other assets don't. So if you have, for example, £500,000, if you're lucky enough, sitting in the bank, only £270,000 passes to your spouse, to your wife, and the rest is split equally between your wife and your children. That might not be what you want. Okay. Also under intestacy rule, it sets out who your estate passes to. So, for example, if you have a wife, it goes to your wife. If there's no wife but there's children, it goes to children. If there's no wife and children, it goes to parents. Now, you might not want your estate going to your parents. It's not tax efficient. And also, it increases their inheritance tax allowance, limit. And also, if you've got elderly parents, do you really want to leave them with lots of money that they don't need? Yeah. Or people worry about money going to parents and then it all being used up for care home fees or for inheritance tax. So it's always better to have a will in place, setting out who your estate passes to. And if you unfortunately don't have any close relatives and your estate passes to, for example, distant cousins, right, or somebody you don't see, it might not be what you want. It'd probably be better if you did a will leaving, for example, your estate to charity. So that would be tax efficient because charities don't pay inheritance tax. So that's one of the reasons why you should do a will. Also, who administers your estate? So when somebody passes away, people assume that when someone's passed away, you can just, take the death certificate down to the bank and the bank will release all the money to you. That's not what happens. You have to have an executor under your will who then, first of all, deals with your inheritance tax liability, then applies to court for a grant of probate. Once they obtain probate, that's what authorizes them to deal with your assets. Now, if you haven't got a will and you die intestate, then who's your next of kin? Who's going to deal with your estate? They're not going to have the authority until they obtain a grant of letters of administration. The application is slightly more complex, takes slightly longer. So it's always a good idea to get a will done and to ensure the will is drafted by a solicitor. So the reason why it should be drafted by a solicitor is that, unfortunately, some people do homemade wills, W.H. Smith will, but they are the most litigated wills because people don't know the formalities of signing a will, how it has to be signed, who it has to be witnessed by. So that leads to a will failing. And for will fails, I've seen so many homemade wills that we've had to go back and, correct errors. And sometimes you can't. Sometimes I had a will once where somebody mistakenly appointed their business partner as an executor and then said my whole estate passes to the executor and then goes on to say the whole estate passes to my wife. Obviously, he didn't want his business partner to benefit, but it was a homemade will. Fortunately, the business partner allowed us to rectify the will and do a deed of variation and change the will.
That must have been a good person with a good heart. Otherwise, some people would have seen the pound signs and been like, I'm taking this to the hills and running.
Yeah. And that happens a lot as well. And the other reason why you should do a solicitor drafted will is, say there's an elderly woman and she does a will leaving everything to her son, but she's got 4 sons, but she only benefits 1.
Okay.
First of all, how do you know the woman, the elderly lady, had capacity to do a will?
Yep.
How do we know she didn't have dementia, Alzheimer's? How do we know she wasn't forced to do the will by the son?
Yes.
Was there any undue influence or duress? So when you go to a solicitor to do a will, we have to keep a full attendance note of what we discussed, whether I felt you had capacity to instruct me, whether somebody came in with her, whether there were other children, and, why are you not benefiting the other 3 sons? What's happened? There may be a perfectly legitimate reason. She may say, I've given money to them in their lifetime, or they're financially secure, this son resides with me. A lot of the times people disinherit their children if one child has provided them with care and support and the other children don't care, never ask after mom, So there's a number of reasons why you benefit certain people under your will, but it's a good idea to get a solicitor to make a note of that, so that if, God forbid, you pass away and then the other children bring a claim against the estate, which they can, because they may feel that reasonable provisions haven't been made for them, then we've got a solicitor's attendance note setting out the exact reasons why, mum came in on her own, son sat outside, mum was clear in her instructions, she had capacity, she knew what assets she had, she knew who she should make provisions for and the reasons why she's not made provisions for some of her children. It could be one son's a millionaire and the other son, has all
doesn't know a pot to piss.
Exactly, lived with mum all her life. So it's things like that. So that's why it's important to put a will in place. And finally, a will is also a good tool to use if you want to set out who the guardian should be of your minor children. So say, for example, I hold all my assets with my husband jointly, but I've got 2 young children. Unfortunately, something happens to my husband and myself. We both die in a car accident.
God forbid, yeah.
I want to set out who cares for my children, who will be the guardian for my children. So I may think, my children are very close to their aunt on my side and, they've grown up with her, and to prevent any sort of upheaval for them, they've already lost their parents. I would rather they went to my sister. So I'd set out who the guardian is for the children. So a will can be used for that, rather than the children, being made a ward of the court and somebody saying we want them or somebody else saying we should have them. A will is a good tool to set that out as well.
That's good. You said some really important things there, which has opened my eyes to a lot of things as well, to be honest with you. And I think I need to make an appointment to come and see you.
I say that
Well, I'm hopefully not going to die anytime soon, God forbid.
Absolutely.
But definitely, there's loads of things that you said, about the whole thing of, God forbid if you pass away and you and your partner pass away, someone to look after your children. That's the first thing that sort of stands out.
Yeah.
And also the inheritance thing. Obviously, you work so hard within our lifetime and you've built an estate, whether it's 100,000 or 100 million.
Yeah.
You want that to be,
for your children.
Yeah, and you don't want to lose all that money to the government at the end of the day. So
you want it to be tax efficient, don't you?
Exactly.
So that's important.
Exactly. And would you say, how long would you say getting doing the process of doing the will with yourselves?
So we normally have a 2-week turnaround, but we do get a lot of clients who, they've booked a holiday and they start panicking, or something might happen to us. Can we get the will done quickly? So we do offer express wills. Sometimes, unfortunately, people leave it until, they're diagnosed with terminal illness and they want the will done quickly. So we can do that.
Yep.
But usually we have a 2-week turnaround. So it's not a long time.
Okay.
But we realise the importance of, when you get the ball rolling, just wanting it done and putting in place. And so usually a will takes about 2 weeks for us to draft. And then we send that out to the client. And if the client's happy, they come in, they sign, we provide a will signing process.
Yep.
If they can't come into the office, we can always take instructions in remotely, send them the will to be signed remotely.
Electronic kind of signature as a wet
signature. So not electronic, wet
signature.
in front of 2 witnesses. So we send instructions as to how a will should be signed. If it's an elderly client, then I do prefer to have a face-to-face meeting just to check capacity, just to make sure there's no, undue influence or duress on the client, which was quite difficult during COVID time. So we were doing Zoom interviews and signing from outside the living room, from the front garden. But, it was important that people had their affairs in order. So, it can be done.
To be fair, a 2-week turnaround is quite fair. Yeah. It's quite fair, I think. And obviously, if people now watching this and they don't have this in place, then they've got enough time to go and get it done.
Absolutely.
And set that time aside, because this is something that's very important, as we say. Now, when it comes to the power of attorney, if somebody has power of attorney over somebody else, they can't go and, or can they? My question is, can they go and do a will on that person's behalf? Or how does it work?
No, so nobody can do a will on your behalf.
Yep.
If you have capacity, you do the will.
Yep.
If you don't have capacity, you can apply for a statutory will. Quite a long process, but it can be done.
Right.
So powers of attorney, they're nothing to do with your will. So I always explain this to my clients, that a will comes to life when you die.
Yes.
Until you die, it's a confidential document. It doesn't have to be disclosed to anyone, and it has no power at all. When you die, your executor's role comes into play, the person who deals with your estate, and then your wishes, your testamentary wishes come into play.
Okay.
Now, imagine that, I'm 60 years old and sadly I'm diagnosed with dementia.
Yep.
I need somebody to deal with my mortgage, pay my bills.
Yes.
Worst case scenario, I'll go into a care home. Somebody needs to access my bank account to pay my care home fees, maybe rent my house out to create an income stream to pay for my care. So a power of attorney gives somebody that I trust authority to deal with my money.
Okay.
To access my bank account, pay my bills, pay my mortgage, deal with my finances on my behalf. Now, it's a good idea to have a power of attorney in place whilst you've got capacity. So I always say, everybody over the age of 40 should think about putting powers of attorney in place.
Sure.
Because sadly, people as young as, 45, 50 can be diagnosed with dementia or Alzheimer's. And also, it's not just mental capacity. Say, for example, God forbid, I was involved in a road traffic accident and I'm left bedbound. I can't go out and deal with my bills. I can't go out and deal with, my finances. It's a good idea to have a power of attorney in place, setting out a minimum of 2, a maximum of 4 people that I trust that can step in my shoes and act on my behalf. So the power of attorney is for your lifetime. Okay. It gives somebody else authority to
help you whilst you're still alive.
Yeah, whilst you're alive. So I've done powers of attorney. I've put them in place. My powers of attorney have been registered with the court and I've just put them away until such time that they're needed. So whilst I've got capacity, I can carry on dealing with my bank accounts. If there comes a stage where I've lost capacity, or actually, you know, I can't be bothered to go down to the bank, and I'd rather my attorneys, which are my children, deal with it on my behalf. They just take the power of attorney down to the bank and say, we're mum's authorised registered attorneys, and so we can deal with her bank account on her behalf.
Perfect.
So that's better than me not having anything in place, suddenly being diagnosed with dementia, Alzheimer's, or even if I go abroad. Say, for example, I decide to backpack around Australia for 2 years, and I want somebody to deal with my finances while I'm gone. So, you know, I've already got my power of attorney in place. With power of attorney, with the property, and because there's two types, there's property and finances and health and welfare.
Right.
So property and finances one can be used whilst I've got capacity. I just can't be bothered to deal with it anymore. Or if I lose mental capacity, then my children can start acting on my behalf. The second power of attorney is known as a health and welfare power of attorney. And that is to be used to make decisions about my medical treatment if I have lost capacity. So it would allow my children to make decisions about whether I should receive life-sustaining treatment, whether I should go into a care home, what care home I should go into, who should visit me, my day-to-day care. So if I can't communicate to the doctors or, for example, social services, then I've got somebody there who knows my wishes, who can say, you know, mum wouldn't have liked to have been kept alive artificially, or mum wouldn't want to be in a care home in Eastbourne, for example. She'd want to stay local so that we can visit her. So it gives them that authority. So the health and welfare one can only be used if you've lost mental capacity. If I can speak for myself and I can say, you know, no, doctors, don't switch off, you know, don't give me this medication, or don't put me in a care home in Eastbourne, then obviously, you know, I've got the capacity to do so. But if I lose capacity, then my children know what my wishes are.
Okay. Now, when it comes to the power of attorney side of things, would you suggest everyone have that done, like, pretty much when they can, as imminently as they can? So then, God forbid, if something happens. And then sort of on the flip side of that, would you suggest that whoever they sort of instruct on their power of attorney, because I think they have to sign.
They do.
So they'll obviously know that they have power of attorney because they have to want to be able to do it as well. Because you can't just instruct someone that they're going to be my power, but then they're like, well, I don't really want this responsibility.
It is a big responsibility. So yes, so the whole process would be that the client would instruct me and tell me who their attorneys are. I would check they've got capacity. So you can't, if you haven't got capacity, then you can't put power of attorney in place. Then you have to apply for a deputyship order, which is quite an onerous, you know, application. It means your deputy has to report to the court every year, has to file accounts, has to take out insurance. And so we don't really want to go down that route. Obviously, I make deputyship applications where somebody sadly has lost capacity, and you know, bank accounts have got frozen. Dad's gone into a care home. Son can't access the bank accounts, and you know, the care home fees are mounting. So then we apply for a deputyship order. It's fine. It just takes a little bit longer to do, and it's quite a bit more expensive. So with your powers of attorney, you can only do them whilst you've got capacity. So part of the process is that somebody has to assess your capacity. So that is a certificate provider, and that usually is me. So I would talk to the client, I would ask them pertinent questions to check to make sure that, you know, they're aware of what they're doing, who they're giving power to, that they trust that person. And then I would draft the documents. The client would come back a week or so later. They would sign the power of attorney. I would sign as the certificate provider, and then they would take it away for their attorneys to sign, or the attorneys would come in and sign in front of me. It would then go off to the Office of the Public Guardian, which is the court that deals with lasting powers of attorney. They would check to make sure the attorneys aren't bankrupt or you know, are sensible people. So, you know, and they will keep an eye out if there's any allegations of financial fraud, or, you know, children accessing mum's money to book a holiday to the Bahamas or anything.
That's not acceptable, you know.
No, but it does happen, Sandy. It does happen, you know, and so we have to make sure that they maintain their duties in accordance with the Mental Capacity Act. So it's all set out in the power of attorney. Again, it's a good idea to get a solicitor to do it, so the solicitor can make sure there's not been any sort of influenced by a child who's trying to access, mum and dad's money, So yeah, that's why power of attorney is important. But it's part of my process when I take will instructions that I always mention powers of attorney, and I always send clients, information sheet about what a power of attorney.
It works hand in hand, essentially, really, isn't it?
And it also just covers me as well, so that tomorrow I don't have, an irate daughter come to me saying, mum's lost capacity and they forced her into a care home, somewhere in Hastings, somewhere far away. And did you talk about powers of attorney? I can always say, I did mention it, but it was something your mum didn't want to do.
Yeah.
But I always say to people, don't leave it until there's memory issues or capacity issues. Just put it in place and it's done.
Yeah.
It's done. It's like, I always liken it to house insurance. I don't know about yourself, but, I've been a property owner for 35 odd years, or probably a little less. And I insure my property every single year in case there's a fire, in case there's a break, knock wood, there's not been anything, touch wood, but you still do it because you worry about, in case something happens. But people don't worry about what would happen if we lose capacity. And sadly, the statistics are that 1 in 3 people are living with dementia at the moment. So, it's always good to have these things in place.
I totally agree. And just time frame wise for doing a power of attorney, I think it's quicker than doing a will.
Not really. I mean, it's quicker from my point of view because I will draft the documents and then I send it off to court.
Okay.
The court used to take about 3 months. And at this moment in time, because of the backlog from COVID and people working from home, it is taking about 5 months to register the power of attorney, and you can only use it once it's registered.
Okay.
You don't have to register your power of attorney, but I always say to people, just register it, get it done, and then it's registered.
That's where you get it out with the little numbers and stuff, right?
Absolutely, yeah. So it says, registered and perforated at the bottom of the power of attorney.
Perfect.
So then you just put it away until it's needed.
And obviously, this power of attorney as well, the people that you have as your power of attorney can't go and use the power of attorney until you unless you become not
lose capacity. Yep, that's correct.
Yeah.
That's correct. So powers of attorney are important. So majority of my work is wills and powers of attorney, but then also sadly I deal with probate properties, and probates where somebody's passed away and they don't have family as executors, and so they want the solicitor to deal with their estate, which is fine.
Yes.
We can do that, and that's where our paths cross because sometimes we need a competent estate agent to deal with probate sales. We know they're going to price the property realistically. We know they know the market and they're going to sell. Probate properties are slightly different from usual properties to sell because they need updating and, so we need somebody who specialises in that. Hence the reason, we've
done business.
Put together because we know we can rely on you to give us a good price and to sell the property.
Yeah.
When someone's lost their parent, they don't want a property sat there for, months and years. They want closure.
It's a heartache, isn't it? Agony for them,
It is because your parents' home or your wife's home or something, you've got memories attached to it. People want closure. They want the property sold and they want to be able to move on.
And sometimes they might still have debt on the property that needs to be serviced, and they might not have the capacity to pay for that mortgage, so they want the job done sooner rather than later at a fair price with someone that's trustworthy.
Absolutely, yeah.
Definitely. Look, Nosheen, you've been great. Dropped lots of good knowledge and information. I'll definitely be coming to see you with my wife, obviously individually, to do our wills and stuff. And hopefully our clients can come and see you as well.
Of course.
So thanks for coming.
You're very welcome.
Everybody, thank you for watching. I'm going to put all the information from Nosheen and her team in the description below. As I always say, don't forget to like, comment and subscribe so you can be informed on all the latest episodes that we'll have coming up. And if you need a will done or power of attorney, you need to go and see Nosheen sooner rather than later while you have the capacity. As you've heard, there's lots of different reasons for the importance of this. So thank you, and I'll see you on the next one.